Young?
Yeah, I think I can start with the rules of engagement and folks can chime in. So good evening. Welcome to the Harvard International Law Journal 2021 Annual Symposium on the Future of International Law, the Impact of the Pandemic and Beyond. My name's Yang and I'm the Symposium Chair of the International Law Journal. Before we start, let me work through a few preliminary matters. To our panelists, due to the time limit of the panel, we respectfully ask you to observe the time allotted to you so that the audience has an opportunity to engage in a discussion during the Q&A session. Our moderator will let you know when your time comes to an end to ensure that everyone can be heard. Thank you very much for your understanding. To our audience, please feel free to submit the questions to our panelists via the Q&A function. You can submit your questions at any time, and we encourage you to submit them early. Our moderators will collect the questions and direct them to the panelists during the Q&A session at the end of the panel. In addition to the current panel, we have 2 more sessions tomorrow. We welcome everyone here to register for those panels under the links posted in the chat, and we look forward to seeing you all there. I hope you all have an enjoyable experience at our symposium, and please join me in welcoming our editors-in-chief.
Thank you so much, Yang. For those who don't know me, my name is Roberta Mayerly, and along with Stephen Wong, I'm editor-in-chief of the Harvard International Law Journal. Once more, it's truly a pleasure and an honor, really, to be here. And I want to extend a very warm welcome on behalf of the journal to our phenomenal panelists today, and of course our audience as well. For those who joined us at our first panel on international trade, great to have you back. For all those newcomers, very happy to see you here as well. And then of course, for those who will join us through the recording as well. Let me say just very briefly how excited we are to be holding this symposium at this extraordinary time, really. The past year has raised many interesting questions about the role that international law can and should play in shaping debates over the global environment, international trade, international institutions more broadly. Those just to name some of the few topics that we will cover during the symposium. We very much hope that this is a time and a forum to think critically and creatively about the lessons learned of the past year, and also the challenges and opportunities ahead, and that this is really, of course, a limited time that we have here. So hopefully this is just the beginning of a much broader conversation. So welcome again. And with that, let me pass it over to Stephen.
Thank you, Roberta. And just before I pass it on to Minsun, our moderator, I just want to echo thanks again to our fabulous panelists. I'm sure you guys are going to learn so much. And we were just joking before we started, perhaps with this recording that will be made available to our students who aren't available due to class or different time zones, that we can see whether some of the predictions or ideas will come to fruition in 5 to 10 years from now. But thank you, and thank you also to our organizers, to Yang in particular, our symposium chair, and to Minsun, who I'm going to pass on to one of our executive editors, and she's going to do a fantastic job, as you'll see. So thank you all, and please enjoy. Minsun, on to you.
Thank you so much, Stephen. Good evening, everyone, or good morning, depending on where you're located for this session, and welcome to the second panel on international solutions to climate change. My name is Minsun Cha, and I'll be serving as the moderator for this panel. It is my great honor to introduce the experts joining us this evening. For brief introductions, we have Dr. Manjyot Ahluwalia, who is the Senior Program Officer for the US and International Climate Cooperation at the World Wildlife Fund. She co-convenes the Alliances for Climate Action, an initiative that provides strategic support to national alliances committed to supporting the delivery and enhancement of their country's climate goals. She's responsible for the global coordination and strategic development for 6 coalitions in Argentina, Brazil, Japan, Mexico, South Africa, Vietnam, and the United States. We also have Professor David Wirth, who is the professor of law at Boston College Law School, where he teaches public international law and has served as the director of international programs. Prior to academia, Professor Wirth was the senior attorney and co-director of the international program at the Natural Resources Defense Council in DC, specializing in environmental issues. He's also been attorney advisor for oceans and international environmental and scientific affairs in the Office of the Legal Advisor at the State Department. Lastly, but certainly not least, we have Professor Sergio Puig, who is the professor of law at the University of Arizona College of Law. Prior to joining the University of Arizona faculty, he taught international investment law and international trade law at Duke Law and Stanford Law School, where he was the SDILS teaching fellow. He also worked for over 3 years in the Young Professional Program for Lawyers and Scholars at the World Bank Group and ICSID, and his practice at leading firms in Mexico City and Washington, DC. So with that, please join me in welcoming our first speaker for the panel, Dr. Ahluwalia.
Thank you so much, Minsun, and it's really an honor, all mine, to join you guys in this very important topic. And I'm very excited and honored to share the floor with the very impressive panelists along with me. All right, so just starting with, let me share my screen and just want to make sure you can see it. Fabulous. All right, so I'm going to be talking to you all today about a whole of society approach in helping meeting our climate crisis and particularly meeting the goals of the Paris Agreement. Before I get started, I do want to share, I live in Washington, DC, originally from India, but in DC at the moment, and I wanted to share one photo of the current cherry blossoms right now, or actually a week ago in Washington, DC, that we experienced very beautifully. But the graph that I do want to show you guys is not to be a dampener, but to say that the experience was bittersweet, because this time the cherry blossoms had their unprecedented early peak, which according to climate scientists say is most likely because of climate change. And I think in 1200 years, this is the first time they peaked as early as end of March. So before I jump on to how we all, and as civil society actors, can contribute to the Paris Agreement, I thought it would just be very quickly give you a history lesson, not too deep, but just let you know a little bit about the UN Framework Convention on Climate Change, which did lay the foundation to the Paris Agreement. And starting with 1992, the Rio Summit in Brazil, which hosted the Earth Summit, the first UN conference on environment and development, which acknowledged that sustainable development requires all types of people and all actors in the society. It also created certain seminal frameworks and treaties, Agenda 21 on sustainable development, which laid the foundation to our Millennium Development Goals, Sustainable Development Goals, UNFCCC, which is the treaty that we will be highlighting a little bit more on, and where parties or national governments are members of UNFCCC, and it is the first international cooperation to combat climate change. And under the UNFCCC, we did see various laws. In 1987, we had the Montreal Protocol to prevent ozone depletion and help address the CFC's issue. And then shortly with the Kigali Amendment, because of the HFC's problem. 1995 was the Kyoto Protocol, which was a binding treaty to address climate change. And then another very seminal landmark agreement, which was the Paris Agreement. So zooming in a bit on the Paris Agreement and giving you a background, it is the very first blueprint for the world where all countries that are parties to the UNFCCC acknowledge that man-made climate change needs to be limited, and we need to respect the safe limits of staying well below 2 degrees and as close to well below 1.5 C, which is the safe limit noted by the scientists. And this agreement was reached at the Conference of Parties in Paris in 2015. and came into effect once it was ratified 11 months after. And what I do want to highlight is that this treaty or this agreement, unlike the impressive agreements that we had in the past with Kyoto and Montreal, this was a very unprecedented and unique agreement. Not only we had 190 plus countries signing on and agreeing to work together on climate change, but it was also a hybrid model, which was a beautiful combination of the top-down model of accountability that comes with any treaty, but also this bottom-up effect where each country could determine on its own what was the appropriate target where it could cut emissions, very based on their emissions development pathway, on their economic circumstances and other unique circumstances. So you did see this top-down accountability framework where every country that is a party to the Paris Agreement puts forward a strong commitment in the form of nationally determined contributions and long-term strategies for 2050 every 5 years, pledging to increase the target. So that's the ratchet mechanism, but also couching it in the circumstances of the country and making sure it's inclusive, it's just, and I think in the COVID scenario, definitely something that incorporates a recovery that's fair and green for all. Soon after 2015, we had the seminal report of the IPCC in 2018 that noted that not just staying and keeping to the 2-degree limit, but it's very important to stay well below the 1.5C. And what a difference half a degree makes. As you can see on the screen, even with the ½ Celsius increase, you see the dramatic increases in extreme weather events in our coral reefs, in ecosystems, in our food systems. This is going to have a devastating impact if we do not respect the limits as noted by the scientists. So what does it mean in terms of numbers? Let's think about the magic number here. So if we need to stay well below the 1.5C limit and make sure we're not overshooting, we need to ensure as a global community that by 2030, we have reduced 50% of our global GHG emissions. And by mid-century, which is 2050, make sure our emissions are net zero. So 50% by 2030 and net zero by 2050 are the golden numbers we have to respect if we want to have a safe future for all. Now let's see the current state of play and where do these national targets stand given the temperature limits. You can see that the nationally determined contributions, the NDCs, put forward by national governments by the year 2020, we've had 77 countries put forward their NDCs, but those only make up barely 30% of the global emissions. We also are waiting for revised and new NDCs from G7 major economies, heavy emitting countries like Japan, China, India. They've of course had their first round of NDCs, but we are waiting for the second round that we hope is aligned as close to the 1.5C target. The picture is a little more troubling when it comes to long-term strategies. So countries, again, are supposed to submit their long-term strategies, and they were supposed to submit by 2020, but given COVID, there have been delays. We've seen that about 29 parties have submitted their long-term strategies of how they want to reduce emissions by 2050. And unfortunately, still only 28% of them, 28% of global emissions are reflected in those countries that submitted it. That means we have a long way to go in the heavy emitters putting out concrete plans. And that's where we see the role of other actors. When Paris came into force, it was very well recognized that even if every country did its bit to put forward a strong NDC or long-term strategy, we still will be falling short of a massive emissions gap that needs to be filled. And Paris was also unprecedented in recognizing the role of not just parties to the national, to the agreement, but also subnational actors. And what do I mean by subnational actors? I mean the youth, I mean companies, investors, local and state governments, civil society, academia, indigenous groups, cultural organizations, all of us, a whole of society, to help meet the goals of the Paris Agreement. And what does this whole of society do? If there is an ambitious company or an investor or a university taking action, it sets a very positive signal to that national government that there are these actors ready for the transition. And this enables that government to put forward bold climate targets. It gives them the confidence. And these enabling policies further encourage all the laggards to then become climate leaders. So this is this positive ambition loop that we hope that this collaboration of subnational and non-state actors and the national governments can together help us achieve the goals of the Paris Agreement. And that's what I mean by a whole of society approach. Now let's really understand what's the potential of these non-state actors or subnational actors, which I'm sorry, I'm using interchangeably. So what is their contribution? Per the graph, if you just take the current agreements, the NDCs and long-term strategy targets alone, they are still putting us and locking us in a very dangerous 3-degree trajectory. But if you combine the national commitments with voluntary commitments of these businesses, of these cities, etc., that can put us on a safe path that is close to 2 degrees. Now, you might ask, how does a city or a company or a university participate in this UNFCCC climate governance? Luckily, there are ways where these actors can participate. There is a formal channel and there are some informal channels. So let me just briefly go through some of those options. A formal channel is one that the UNFCCC has recognized. It's called the Marrakesh Partnership for Global Climate Action. And a little bit about that, it was created under the UNFCCC to strengthen collaboration between governments and key stakeholders, such as subnational actors, to address climate change. And in COP21 in Paris, 2 high-level champions were assigned to lead this work. And these are representatives of civil society. And they are created to create this durable connection between subnational actors and national governments. And in Marrakesh, which was the Conference of Parties in 2016, formally this partnership between subnationals and national governments came under the banner of the Marrakesh Partnership for Global Climate Action. Some of the things that this Global Climate Action Agenda does is that it helps and works with subnational governments, subnational governments and non-state actors set high commitments through different campaigns such as Race to Zero, Race to Resilience, and breakthroughs in certain sectors such as transport, energy, power, land use, agriculture. And it creates a durable space for very ambitious subnational actors and national governments, and together they can help achieve the goals of the Paris Agreement. But despite all these efforts, we are still seeing that engagement at the national level of these companies, of these cities, universities is lagging behind. Just as a very quick overview of all the commitments taken by cities, we see that most of these cities fall in the global north. We still need to reach the global south. We still need to reach the diversity of actors beyond your usual suspects of companies and investors and cities and states. We want to work with the youth. We want to work with indigenous groups and all other parts of the society to meet our goals. Just like there are barriers at the global level of a lack of diversity of actors, there are barriers also for climate action at the domestic level. There are not enough actors taking climate action, so we definitely need to increase that scale. And if only a few actors who are taking action are ready to speak up publicly about the opportunity to take action on climate and the urgency of climate action. And we've seen that even though these actors are taking action, they are very siloed. A city is working with other cities, companies working with other companies. We need to make sure that this is a cross-sector, cross-actor path that we take. And that is the goal of this initiative that I'm working on at WWF along with our global partners. And this is called the Alliances for Climate Action. And it creates these coalitions of actors that are cities, states, businesses, universities in different parts of the world to help them deliver an inclusive transition to 1.5C. And they do this by encouraging climate action individually and collaboratively, encouraging champions to speak up more publicly about the opportunities of this inclusive net zero transition, and advocating to their national governments, demanding for bolder climate policies. So together with WWF, you can see in the inner ring, we have global partners such as CDP, Leaning Business. They work with different constituencies such as companies and cities, etc., on taking bold targets. We have other national partners domestically, and then we have signatories, which are your very known brands that you can see on the screen. Together, we've been able to mobilize 4,500 actors across our alliances. Very quickly on the map where these alliances are, across different regions, America is all in, which was we are still in, which was created during the Trump administration to be a strong and positive force for climate action. Mexico, Brazil, Argentina, Australia, Japan, South Africa, and others coming along. And together they represent over 50% of global GHG emissions. So that's significant. And this, I think I'm a little short of time, but this just shows that at different points of time, starting Paris, how the different subnational actors have interacted, and the latest one being the road to Glasgow, which is COP26, and of course, a very interesting opportunity of the Biden summit in April. And President Biden has invited over 40 countries to participate in the summit, and there will be some subnational events happening in that week of the summit. To summarize, I think it's very clear that all are needed in this road to COP26 and beyond. And to be aligned with 1.5C, we need a whole of society approach, critical role of both national and subnational actors in the UNFCCC governance process, which is evolving. And we need to activate this positive ambition loop of bold climate action by subnational actors and demand for higher ambition to our national governments. And it's only through radical collaboration that we can get through those breakthroughs in key economic sectors that are so material to the emissions of a country and the GDP of a country. And together, I think that in this decade, from now to 2030, we can deliver. I'd just like to end with a very compelling quote from Antonio Guterres, who is the UN Secretary General, and he talks that multilateralism, the new face, needs to be everyone, and together we can fight this climate crisis. Thank you, and I'll stop share, giving the floor to David. David, I think you're on mute unless it's just me who's not able to hear you.
All right, is that okay now? Sorry about that. I use Zoom. Yeah, you would think I would get used to it. All right, thank you very much, Manjyot, for that very enlightening presentation. The past year has been something of a blur, but one thing I do remember is that I was asked to speak at this symposium last year. And so both a current and a very delayed thank you for the opportunity to be here. The organizers asked me to speak about potential climate litigation in international tribunals. And just as a bit of background, the United States historically has been a very great supporter of international arbitration. That is, reference of disputes in a Pacific dispute settlement mode to binding neutral third party, usually binding arbitration by actors who are acting in their personal capacities and not on behalf of governments. This is actually an excerpt from the greatest hits of 1915. Let nations arbitrate their future troubles. It's time to lay the sword and gun away. this movement was a social movement, and a century ago was part of the popular culture. You're welcome to compare that to Justin Bieber and Britney Spears if you choose, and draw your own conclusions about where American culture has been in the century since. The building behind the quote is the Peace Palace in The Hague. It was financed by Andrew Carnegie as part of, again, this social movement, and it houses the International Court of Justice, which is not a court of general jurisdiction, such as the courts of Massachusetts, but it is a standing international arbitral tribunal, the difference being that states have to consent to having disputes heard there. What I'd like to first try to convince you of, hopefully successfully, is that the international judiciary is indeed quite receptive to claims based on environment. The urtext in this field, the original source material, is the Smelter Arbitration of 1941. This was a dispute between the United States and Canada. Canada had and still has a smelter on the other side of the border that was polluting with sulfur fumes, polluting Washington state landowners' property and injuring their health, their crops, their livestock. This is a standard international dispute that comes under the guise of diplomatic protection. You have to remember that states and only states, with a couple of exceptions, are subjects of international law. So international law, with the exception of some areas such as human rights and hopefully not us, but international criminal law, does not apply to individuals. It applies only to states. So this is your standard international dispute. The landowners petitioned the United States government to espouse their claim, which is framed in legal terms against Canada, dealing with the smelter. So the action has to move to the international level, and the espousal process is the way that that occurs. It's important to recognize, which many of my students don't when we first start discussing this, that there was no treaty involved here. This is a claim under what's called customary international law, international customary behavior that's not written down, but that is nonetheless legally binding. In this particular case, there was also a compromis. That's not a typographical error, not a compromise. A compromis, an agreement to arbitrate. It was sent off to a tribunal of 3 independent personalities appointed in their personal capacities, the chief arbitrator being of Belgian nationality. The tribunal rendered an award, which is very famous in this field, that under principles of international law, no state has the right to use or permit the use of, that's the smelter, its territory in a manner so as to cause injury when the case is of serious consequence and injury is established by clear and convincing evidence. Think about this qualification when it comes to climate. Not always so clear from an adjudicatory point of view that the case is of serious consequence. Collectively, yes, but maybe not a particular one, and the injury is established by clear and convincing evidence. Since then, there has been an explosion of international litigation, including in the International Court of Justice, in the mode of what are called contentious cases, that is cases that have identifiable parties. Most of these, or not all of them, get there through the same process, which is an agreement to arbitrate. 1997, a dispute between Hungary and Slovakia over the Danube River. Pulp mills, an international pollution case in 2020 that established the international responsibility to perform environmental impact assessments, such as NEPA in the United States. And then, excuse me, whaling in the Antarctic from 2014, which concluded that the Japanese whaling program intended for scientific purposes was in fact no such thing. The organizers asked me then there are others tribunals, the International Tribunal for the Law of the Sea, the Permanent Court of Arbitration, which also lives in the Peace Palace. Another case between Ireland and the UK established the duty to cooperate in this field. The organizers asked me to focus specifically on advisory opinions. I'm sure your constitutional law professor teaches you that there is no such thing, that they're prohibited under Article 3 of the Constitution of the United States. That doesn't necessarily mean, at least in federal courts, that doesn't mean that they're a bad thing. In fact, they can be a very good thing. So one example is an advisory opinion on nuclear weapons from 1996. The question asked there was whether the maintenance of nuclear stockpiles and the potential deployment of nuclear weapons was consistent with international law. The court ultimately answered no, but the way that I teach this case is that for the environment, it was actually a win, because you have the ICJ, the International Court of Justice, in fact, codifying the principle of the trail smelter all the way back to 1941. And about advisory opinions, well, one other point about advisory opinions is that they very much engage the public, as Dr. Ahluwalia just pointed out. The request for an advisory opinion on nuclear weapons was in fact a joint project of the, I have to look at my notes here, the International Association of Lawyers Against Nuclear Weapons, so lawyers, the International Peace Bureau, and International Physicians for the Prevention of Nuclear War, which lobbied governments to adopt a resolution in the United Nations General Assembly by a majority vote requesting the advisory opinion. Individual states typically cannot request advisory opinions. It is international institutions that can do so. And then last, we have a different category, which is the subject of the previous panel, trade agreements. They're different in kind. Trade agreements constrain state behavior. They create a liberalized trade environment by removing constraints to international trade. But even there, we've seen plenty of progress through Brazil tires, in which the appellate body of the WTO, which is the institution on the back screen, opined in dictum that climate would be an appropriate subject for treatment under trade rules. Less so, two other areas dealing with food safety. The appellate body in two disputes, beef hormones and biotech, concluded that the precautionary principle was not customary international law. So one thing to keep in mind is that if we're engaged in litigation, one needs to think like a litigator, that is strategically. So there have been a number of proposals kicking around for a long time, about requesting an advisory opinion on climate. This is the most recent one that I could find, Pacific Students Fighting Climate Change. If you look at the screen, you see governments referred to, the foreign ministers, that would be for the United States, Antony Blinken, although the United States is not a part of this forum. Second of all, an advocacy group, Pacific Students Fighting Climate Change. That's a non-governmental organization, a non-state actor that Dr. Ahluwalia was referring to earlier on. And then last, they were looking for supporters among academia, including Cambridge, Harvard, Yale, and other institutions. I personally didn't sign this statement, and let me tell you why. The reason is this precise question yet to be decided. I was wary of supporting a proposal that seemed vague and undefined. And so let's talk a little bit about the litigation aspect of an advisory opinion. It must be phrased as a question of law, emphasis on of law. We all know that the science supports, as we just heard from the previous presentation, very, very large reductions in emissions. The question would be, what would the ICJ add to that in terms of the law? Typically, they're short. Here you have the example on the nuclear weapons advisory opinion. Basically, the answer is yes or no. And the outputs need to be clear, so that one needs to frame the question in a way that the International Court of Justice can wrap its arms around a legal question, number one, and second of all, produce a result that is meaningful. Impediments in this area include what every international lawyer, every professor of international law refers to as sources of law. Custom, that's the trail smelter. lack of clarity as to the contours. Remember those exceptions, those tricky exceptions. And then the other would be treaty, which in this area is primarily the Paris Agreement. The Paris Agreement contains many non-binding elements, including those all-important nationally determined contributions that the previous speaker was talking about. They're contributions, they're not commitments, they're not law. The binding obligations are largely procedural. We just heard the duty to engage in a stock take and periodic revision of the NDCs. The US, by the way, is coming out with its NDC, I believe on Earth Day, April 22nd, coming up. The convention that she referred to, the UNFCCC, includes principles, but who knows exactly what they mean. The precautionary principle is not customary international law, or arguably not. The appellate body has told us that. I was just on an international environmental moot court bench where I asked one of the participants, well, the principle of common but differentiated responsibilities, what is its legal content? Are there any interpretations of it? And the answer was no, at least from this particular litigant. So it likely requires reverse extrapolation from some endpoints. And we heard from the previous speaker, 1.5 degrees or 2 degrees. The existing NDCs in the first round, my understanding is, do not keep us below 3 degrees Celsius. So we need to, a useful output would be emissions reductions timetables. But there is one case coming out of Holland, coming out of the Netherlands, in which the Dutch court did instruct the Dutch government that its target of 20% emissions reduction was inadequate, and instructed it to increase that to a range of 25 to 40%. So it's not out of the question. It's just that the question needs to be framed in an appropriate way, and against the background of a judiciary that we can assume is sympathetic to, based on the prior jurisprudence, to resolving situations like this. And my last slide deals with a contentious case. That would be United States against Canada, the Trail Smelter. That would be Hungary against Slovakia. That's the Gabčík-Beneš-Maros dispute. Even more challenging, one has to establish jurisdiction, either through an agreement to arbitrate or otherwise through the ICJ, through what's called its compulsory jurisdiction. There's also a question of locus standi. This came up, standing to sue. This came up in Massachusetts against EPA. Causation, attribution, to what extent is the state responsible for the emissions that are occurring? Remember the Trail Smelter. The state has the responsibility to control private actors within its jurisdiction, but how far does that go? And the allocation of responsibility and the all-important question of remedies. This is when we're talking about state-to-state dispute settlement in a concrete case that your constitutional law professor probably would approve of as a case of controversy under the US Constitution. So I think there's plenty of opportunity there. I wish the students who are pursuing an advisory opinion well. In fact, when this came before ministers, it did not get adopted, the proposal to request an advisory opinion. It was rejected, at least from what I've read in the press reports, by Australia, and so it didn't occur. Once we've gotten past that, I think there's reason for optimism, but do bear in mind that whenever we're in the Peace Palace, whether in a contentious case mode or in an advisory opinion mode, it is litigation and it's unpredictable. So thank you very much. And I will pass the floor to the next speaker.
Thank you, David. And thank you for the organizers. It's really a pleasure to be here. And I'm gonna be very brief in part because we don't have a lot of time. And I really think that will be nice to engage with the students and their questions and answers, right? I want to link these two conversations. The one started by Manjyot about the private sector's role in the climate crisis, and David's point on litigation as well. And I think a good meeting point is what we think the future of international investment law could be, right? If we were a little bit more ambitious than the current reform happening around the UNCITRAL forum, right? For those who do not know, right, there's like a forum right now taking place. It's being debated in the context of UNCITRAL and the way forward with the investor-state dispute settlement, a very controversial way, dispute settlement form involving investors and states. But let me just very briefly explain what I mean, right? So the restructuring of the global economy requires a low carbon future, and I think we have heard that without that, right, without a more activist role by the private sector, there's grim prospects even with the Paris Agreement. There is also this paradoxical impact of climate change that basically is extremely regressive, right? The states who will be most affected are the ones that contributed the least. And that's how I think international trade, investment, finance, and intellectual property laws must think about what's coming, right? How the laws can actually be part of the solution, either by thinking, well, maybe carbon tax adjustments in the case of trade, or maybe waivers for some patents and licensing of technologies in case of IP. But in investment law, I think the main challenge is to think of how this can support the energy transition. And this is a very important question, right? Because right now, according to the International Energy Agency, there is a need to increase at least 2.5 times by 2030 the annual budget or annual expense in global low carbon energy projects. And this has to increase, these dramatic ways to get to 1.5 trillion. Right now we're less than $500 billion. The private investments will provide most of these, right? And we need to think creatively about how to kind of like trigger that or the catalyst of that power, right? The power of the private capital, especially now in light of the COVID crisis that has pointed to the limits, right, that we may face if we not use the amount of resources that we have to adapt in this way, right? So some of us believe that the COVID-19 crisis can be an accelerator of climate change and renewable action rather than the opposite. Now, the international investment law reform, as I was saying, has been mostly focused on resolving or adapting investor-state dispute settlement, or if anything, in talking about this right to regulate, right? And it's kind of missing the boat of what's coming in the 21st century. It's trying to adapt to or trying to resolve a problem created in the 20th century, which was as a way of creating or facilitate the disputes, the international disputes involving investment. A political economy was created where the main beneficiaries of the process of litigation around investment are the lawyers and the arbitrators and the stakeholders around this litigation. So the question really is how to use that as opposed to just reform that. And the origins of ISDS is actually completely linked to oil and gas arbitration and other technologies that right now contribute substantially to carbon emissions, like mining or quarrying and what have you. One example of this link is the main promoter of ICJ, the part of the World Bank that deals with investment disputes was actually the Director General of a special fund of OPEC, right, Organization for the Economic Cooperation around petroleum. So there is also very limited reference in the international investment agreements of the UNFCCC, right, the UN Framework Convention of Climate Change or Paris Agreement, and you know, there is a problem, right? There seems to be a disconnection in understanding what is the future in this, right? Climate change policy has, in fact, now already appeared in the background of over 50 investment treaty arbitrations dealing with renewable energy. Some of them, perhaps, with more. The best known is the Vattenfall case involving the cancellation of nuclear energy permits, but also the cancellation of subsidies for green energy in Spain. In fact, the EU has decided to modify, the ECT, which is the Energy Charter, to allow the suspension of subsidies in this sector. So what is the problem, right? Well, the problem is basically realigning international investment law with climate change policy to promote sustainable foreign direct investment and redirect finance flows away from fossil fuels. And at the same time, do what is known as the risk, or limited the risk of green investments. So in some way, bilateral investment treaties and international investment agreements may help in these dual goals. Investors in renewable energies are exposed to regulatory risk as any other investors, including the risk of sudden withdrawal of policy support. Renewable projects are also exposed to currency risk, and I can explain more in the Q&A. And foreign investors may face discriminatory local content requirements and being affected by sudden changes in policies. So what are the solutions that I think we see in the near future? Well, the first one is one option that was adopted in the context of the USMCA renegotiation, which was either excluding completely ISDS in some areas or between some countries, or exclude some sectors that don't need the incentive or the additional protection, right? And we have like some candidates here which are very obvious, right? Oil and gas, mining, and those high carbon emissions sectors. Then the international investment agreements can also be used to tie protections to policies that redirect financing away from carbon intensive industries. And this can be done through mandatory disclosures, which disclosures can be serve as the basis for actions against investors. And here I have in mind litigation of the kind of the type that we see in the U.S. courts as key time or other citizen actions based on failure, deception or deceiving disclosures that can be tied to specific policies, like some type of thresholds connected with carbon emissions. And I think this is the main point, that in the process of reform of the ISDS or international investment law, we have not seen that the lawyers can be part of the solution, right? There's a very important political economy now around ISDS that's not going to go anywhere and could be used to enforce some of the commitments of the Paris Agreement. This also can be done by creating treaty protocols that provide special regimes within the international investment agreements for green investments, meaning special subsidies, special rights, special MFN clauses, right, that can actually allow them to have a better possibility of success. And I think this is another interesting idea that has been now discussed by some scholars like Bonicia and Eisbeth, that the compensations, the rules of compensations in bilateral investment treaties that basically establish the way of accounting for the damages of investors suffer when governments take action can be redesigned or interpreted to take into consideration international environmental obligations. This, in essence, may lead to the reduction in the awards in cases involving unsustainable investments that do not really account for the externalities and the consequences of their products. And in short, I think the main takeaway that I want to leave you is I think we're selling the reform of investment law very short. We have to be more ambitious. And one way to be more ambitious is to link this to what is going to be the next big battle of, or what is the big battle of our times, which is climate change and climate justice. With that, I think we should have a nice engagement. Thank you.
Thank you so much to all of our speakers for the extremely informative presentations. We have a few questions from the attendees in the chat. And to begin, I think we have one for Dr. Ahluwalia regarding the critical role of diverse actors in pushing for the net zero goal. In what ways do you think we could reach out to those groups and engage them in climate governance?
Great, thanks for that question. Not an easy answer, but I'll try. So as I noted in my presentation, there are different channels for these different actors to participate in the Paris Agreement and in the larger UNFCCC process. So the formal channel, which has its blessing of the UNFCCC, is the Marrakesh Partnership for Global Climate Action. And I'll just tell you a little more about how those actors can be recognized and net zero can be driven. And the informal channel that I mentioned was all these partnerships and contributions and voluntary commitments of actors. And I gave an example of Alliances for Climate Action, which is at the national level working with these actors. But I think there is tremendous potential for both to do more. Specifically for the formal channel, I just want to say, like, just sharing this really quick, the Marrakesh Partnership actually launched a campaign called Race to Zero, and it is backed by the UN, and it has the participants of all these subnational actors. And the goal is to get these cities, businesses, universities, investors to set very bold net zero goals and interim 2030 goals aligned by 1.5. And ultimately, the goal is to create more and more of these actors at COP26, which, like I mentioned, creates this positive ambition loop, which sends a signal to the national governments that they need to also do more. So as of now, who's in the race? There are about 400 cities, 23 regions, over 1,500 businesses, 85 investors, and almost 600 universities now that have committed to 1.5C aligned 2030 and net zero 2050 targets. And you can see the statistics of the number of emissions and the GDP and the people they represent in this race. And ultimately, and I'll just stop sharing, these actors are fed into something called the Global Ambition Alliance. And that's an alliance where all these net zero actors and the governments that have taken long-term strategies and NDCs aligned to 1.5C can work together to come up with solutions. So that's like the formal piece. And of course, the informal one is the alliances that I talked about. The goal of both these informal and formal channels is to increase the diversity. Again, we are seeing a lot of challenges to hitting at that diversity. We end up getting the usual suspects. But another question that came in the chat is, what is leading to the challenges? Why are we not being able to capture the global south or the other actors in the economy? And I think there are many reasons for it, but one could be the lack of tracking of commitments. There are probably actors taking action, but they're not being tracked in a very formal way. And perhaps as Sergio mentioned, disclosure can help. The more actors that disclose publicly what they're doing, it can help with the tracking for national governments as well as internationally. And I think, just creating a more transparent channel between national governments and these actors, when these national governments are deciding what should be the level of ambition for their climate targets, there are stakeholder consultations, but are they truly transparent? Are they truly inclusive of all stakeholders? Or is it your usual fossil fuel interest that ends up being a countervailing force to positive green groups? So I'll just stop here and give the floor to others to answer their questions. Thank you.
Thank you. Next, for Professor Wirth, for potential advisory opinion, is there a question of law you would like to see asked of the ICJ, or one that you recommend? Or perhaps a question that you are concerned about being asked? For example, if the question of law is premature or could lead to an adverse ruling.
Thank you very much for the question. And it's directly on point, of course. As to the timing, let me set that aside for the time being. And let's assume that the advisory opinion goes to what in this line of work is called mitigation, which means emissions reductions. The Paris Agreement also deals with adaptation and also funding. Those are less amenable to legal treatment in an advisory opinion. So one has to think about what sort of output would one want, number one, and number two, to what extent is a court capable of delivering that? The IPCC, for instance, has been sounding the alarm for quite a long time and has identified goals in terms of emissions reduction. I went to the COP24 in Poland, and the head of the IPCC was very clear about the major reductions that are called for pretty much immediately, as Dr. Ahluwalia pointed out in her presentation. So what exactly can a court add? The answer is to translate policy goals, to translate the science into a legal obligation, presumably on the part of all states. If we start to reverse engineer to particular states, I think then we're going to run into trouble. But that's the purpose of the Paris Agreement and the nationally determined contributions. Again, they're not commitments, and the court would be aware of that. So what exactly can the court add? And I would suggest that from having worked in this field for quite a long time, more than 35 years, if it's not attached to a number, as in the Netherlands case, it's not necessarily worth an awful lot. So, I mean, one could imagine a statement that is framed in legally binding terms about the obligation to make reductions, but how is that actually going to influence the negotiations? Because that's where the action is. The Paris Agreement is the only game in terms of emissions reductions. So it has to be framed in legal terms. You have to anticipate what is the desirable output, and we're looking for maybe a global number. Now, the good news is that the ICJ, particularly in the whaling in the Antarctic case, has indicated no hesitation in engaging directly with scientific questions. So taking the IPCC information, IPCC is a UN body, and translating that into law, presumably is something that could conceivably happen. Actually, I was originally trained as a chemist, and I was quite, from my point of view, pleasantly surprised to see the court's willingness to engage on scientific questions. So you can imagine that there would be some capability to take the work product of the IPCC to translate it into global obligations, and arguably to attach a number to it. Now, then the question would be, do we want to identify a number and a target? Not so much the timing of the request for the advisory opinion, but as Professor Ahluwalia was suggesting, timing in this line of work is everything. We wasted a lot of time in not making reductions that could have been made early and cheaply and had significant environmental benefits. Now we're in the end game and everything has to happen faster and the benefits are likely to be fewer. So the law, and it has to be framed by reference to, and the third point is it has to be framed by reference to sources of law. Custom in this area, that is the law that's not written down, that's the trail smelter, I would say is ripe for elaboration by the International Court. The Paris Agreement, somewhat counterintuitively, it is not that helpful. In fact, I went back and looked at the text of the Paris Agreement, which says that it aims to limit warming to no more than 1.5 degrees or 2. Actually, it's framed in terms of 2 and in the alternative 1.5. Well, aims to me as an international lawyer sounds like non-binding, a hortatory expectation that's not necessarily binding. How does that translate into the law? Well, the agreement could be evidence of what the law is, the customary law in the trail smelter mode. And you can imagine you could write the brief, you could write the advisory opinion that one might want to see that makes that connection between the two of them. A non-binding exhortation in the Paris Agreement, which to be clear is itself a binding agreement. But, and then to customary international law. So it's a challenge. I don't have a, as my answer to the question is, I hope indicating, I don't have a fixed opinion on that, but one needs to frame the question and the anticipated answer in a way that's actually going to help the negotiations along, that's going to give it a kick in the pants so that when Tuvalu, a small island state, takes the floor in the UNFCCC conferences of the parties, it can say, well, the International Court of Justice told us we have to do this. That's where you really want to get. And those all important NDCs, which are contributions, I almost slipped myself, contributions by in terms of a mitigation mode would, you have to reverse engineer to the NDCs. In terms of the timing of an advisory opinion, quite honestly, I don't know that there's an awful lot to be gained by waiting. I mean, the reason one would wait would be because one expects a maturation of the law. The law is actually fairly robust at this point. I mean, the way I always teach this to my students is it's like going out on a starry night, looking up at the constellations and trying to determine what the ancients saw. I mean, if I go outside and look at the constellation of Cassiopeia, the ancients saw a queen sitting on a throne. The best I can do is something that looks like a W. Is it a queen sitting on a throne? Is it a W? Well, the answer is in the eye of the beholder, and the court can take an advisory opinion as an occasion to move the law along, which it did in the nuclear weapons advisory opinion. I don't know that there's an awful lot more in terms of basic principles to be litigated and established. I mean, the law is there, it's spotty, and it's sometimes squishy, and sometimes less than clear. But I think we can count on the ICJ, and this is the optimistic note I'd like to end on, we can count on the ICJ to understand the significance of the opportunity to move the law along, contribute what it can. It is an organ of the United Nations. It is the chief judicial organ. The IPCC is a UN organ that is involved in strictly science. The ICJ is the chief judicial organ, and I think we can trust the judges to the ICJ to seize the opportunity to move the law along if we give them the opportunity in a correctly phrased question.
Thank you, Professor Wirth. For Professor Puig, what do you think are some of the most significant obstacles to seeking the enforcement of the Paris Agreement through investor-state dispute settlement, and how, if at all, can we overcome some of these obstacles?
Yeah, well, the main obstacle is that generally they are not enforceable, right? There's obligations that are not enforceable by investor-state dispute settlement, right? And for instance, you can make that distinction easy in the USMCA or the NAFTA, right? Where basically the enforceable, there may be other obligations within the chapters regulating investment in free trade agreements, but the enforceable ones are basically 5, right? Fair and equitable treatment, minimum standard of treatment, no performance requirements, no expropriation without expropriation, national treatment, and MFN. Now, there may be ways in which creative lawyering can link them to some of these commitments, especially if governments commit to a particular policy and then they reverse that policy. If that policy is linked, right, the original policy is linked to the Paris Agreement and creates incentives, and then there's a specific expectations created, perhaps in writing by the government, there may be ways in which those commitments can be relevant in the enforcement of investment protections. But I think what I'm talking here is that a way to go around that question, which makes it very difficult to enforce, may be that the investment opportunities are conditioned to the use of disclosures and the proper disclosure of information, and that then can be used for other type of enforcement, either through arbitration but also to domestic court litigation against investors. Against states, I think it's going to be difficult, right? That these type of international obligations get enforced, right? As I said, right? You know, maybe a very broadly drafted provision under fair and equitable treatment may allow to bring some of these obligations, but I think it's probably difficult.
The Minsun has given me leave to jump in at this point. I just wanted to make one comment about the investment regime that's to a considerable extent equally true for trading goods, which is the World Trade Organization. The obligations in bilateral investment treaties or in the WTO suite of agreements are fundamentally negative. You just heard Professor Puig describe, it prohibits this, it prohibits this, it prohibits this. And the whole idea is to get governments out of the business of interfering in establishing trade barriers, maintaining trade barriers on the one hand, or interfering with the free flow of capital on the other. And there's a fundamental disconnect between those kinds of agreements and the Paris Agreement. I mean, the trade and investment agreements include a series of don'ts. They're negative obligations, similar to the US First Amendment. Why do we have freedom of expression in this country? Because the government is disabled from interfering in the free flow of ideas, and the Supreme Court will enforce that. So saying that they're negative doesn't mean that they're bad. But the obligations in the Paris Agreement are fundamentally different in kind, which is that the expectation is that governments will step up and do something and to dip into an otherwise unregulated market. I mean, it's lack of regulation that's gotten us into the mess that we are now. So the two of them come together in a way that they're really butting up against each other. And the trick is to frame these governmental actions in a way that meshes. So for instance, the WTO suite of agreements specifically says that it's dedicated to sustainable development, and the rest of it is entirely deregulatory. I mean, is deregulated trade sustainable trade? I would suggest not. Is deregulated investment sustainable investment? If we're trying to encourage green investment, I would suggest that the answer is not. So we need creative lawyers of the next generation that can step up and mesh these two. So for instance, one creative approach might be to look at the failure to the absence of green investment as somehow a subsidy that's climate unfriendly, right? This is a climate degrading act. It costs the world enormously in terms of the adverse impacts on the climate, and that would put a thumb on the scale in terms of green investments. The trade regime is hostile to measures that are based on process and production methods, which applies, for instance, to carbon taxes. So you don't see, I mean, it doesn't affect the finished product. A product that is manufactured with dirty fossil fuels doesn't look any different from a product that's manufactured with renewable energy. So there really needs to be a place in which these two kinds of regimes can come together and to start working together towards what is truly sustainable development. The idea of sustainable development is mutually complementary. Development and environment go hand in hand so that the legal and the legal obligations mesh as well.
I'm afraid we're out of time, even though as much as I'd love to hear more about the different ways, you know, different actors can come together for this important issue. But thank you so much to all of our panelists for sharing your expertise on this topic, and also to our attendees. And we hope you have a wonderful rest of your evening. Thank you.
Thank you.